Thank you, Ray, and thank you to the Miller Center for engaging us in this very important discussion this evening. To understand all of the aspects of the resolution before us, one needs to understand both sides of it in terms of both the threat to our security as well as the meaning of constitutional privacy. We cannot understate the threat. We experienced it. We're some years away from 9/11, and sometimes those years have given us a sense of security and a desire for normalcy, a return to normalcy, but the threat is quite real. And indeed, it is quite difficult often to state. It consists of a loose and deceptive set of alliances: Al-Qaeda, hosted by the Sudan and Afghanistan, the totalitarian theocratic regime in Iran, the fanatical and oppressive Wahhabism theory in Saudi Arabia. It is a set of opponents who are loosely affiliated and very, very wealthy from oil. In fact, it's fair to say that the United States is paying for both sides of the conflict. They have, in fact, manifested a great disregard for human life as well as little fear of death. That's the threat side. It's real, and it must be addressed in realistic terms. On the privacy side, there's no question but that the Fourth Amendment, as the setup piece indicates, guarantees a right of privacy. But what's the nature of that constitutional right? Well, like all constitutional rights, it cannot be absolute. It cannot be categorical. It's not an absolute guarantee of secrecy. Why can't it be that? Because it has to take account, as this debate must take account, of both the interests of security as well as privacy. And the standard that the court uses to reconcile those two is the standard of reasonableness. And reasonableness itself has two sides. Reasonableness of the government to the individual, to respect the dignity and the liberty of that individual, as well as reasonableness of the individual to the community, to respect the obligation, if you will, to be a good citizen. Now, how is reasonableness applied to this context? And context is very important, because every Fourth Amendment case always depends upon the totality of the circumstances. One of the things that I think is essential to understand is that we are not dealing with individual criminal acts. We're not dealing with a specified individual person who we think has committed a crime, and therefore we can go get a warrant for that particular person or the particular thing or the particular contraband that they may be involved with. Instead, as the Fourth Amendment is applied in the context of the war on terror, of this threat that we confront, we're interested not primarily in prosecution, but in preemption. We're interested primarily in making sure that chemicals and biological weaponry are not released, in fact, throughout our population, threatening millions of our citizens. So, if in fact the criminal structure that depends upon probable cause and a warrant in advance is ill-suited to this understanding of the threat that we confront, and it is ill-suited because let's remember that the imposition of those requirements meant that Colleen Rowley in the Minnesota office of the FBI could not get a warrant in advance to search the computer of Zacarias Moussaoui. It meant that the FBI would not trace telephone numbers that they had in hand, calls being made to a location in Yemen that would have tied those individuals in San Diego, California, who ultimately were part of the flight that crashed into the Pentagon. We need instead an alternative structure that I would suggest consists of three parts. One, that assesses the programmatic need for surveillance. Two, a means that is proportionate to meeting that need. And three, a respectable and responsible means of oversight in terms of administrative sanctions for those who abuse the power and set it in a direction contrary to our protection. Thank you.